This is Dr. Dorenzo. I want to welcome you back. We're going to cover component 6. This is the component about abuse and domestic violence. Really an unfortunate topic, but certainly a necessary one because we know that abuse does occur pre-divorce, post-divorce, and abuse is certainly included in domestic violence. So domestic violence is a pattern of controlling behaviors, violence or threats of violence that one person uses to establish power over an intimate partner in order to control the partner's actions and activities. Domestic violence is not a disagreement, a marital spat, or an anger management problem. Domestic violence is abusive, disrespectful, and hurtful, or hurtful behaviors that one intimate partner chooses to use against the other partner. You may be experiencing domestic violence if your partner is doing any of these or other unwanted behaviors. Hurting you physically, slapping, hair pulling, strangling, hitting, kicking, grabbing excessively, squeezing or shaking, twisting your arms, burning you, or intentionally injuring you in any way. Using your children against you, calling you names and hurting you emotionally, harming your pets, acting with extreme jealousy and possessiveness, isolating you from family and friends, threatening to commit suicide or kill you, controlling your money, withholding medical help. Signs of domestic violence: somebody stalking you, demanding sex or unwanted sex practices, withholding medical help, hiding assistive devices, minimizing the destructive behavior, threatening to out you if you're lesbian, gay, bisexual, transsexual, or transgender, controlling you with that certain look in his or her eyes or certain gestures. If you're a victim of abuse, you are never to blame. It is not your fault. All of the tactics above are abusive, and some may also constitute a crime under the Florida statutes. Domestic violence is an urgent public health problem with devastating consequences. Approximately 5.3 million cases of domestic violence occur each year in the U.S. to women aged 18 years and older, while 3.2 million cases occur to men. Studies suggest that up to 10 million children witness some form of domestic violence annually. Every day in the U.S., more than 3 women are murdered by their husbands or boyfriends. Women aged 35 to 49 were the most vulnerable to intimate partner murder. Men who, as children, witnessed their parents' domestic violence were twice as likely to abuse their own wives than sons with non-violent partners. In Florida, there were 107,666 acts of domestic violence reported to law enforcement in 2015, or 543.4 per 100,000 residents. To report any instances of domestic violence, call the toll-free Florida Domestic Violence Hotline, 1-800-500-1119. And to learn more about domestic violence in the state of Florida, visit www.fcadv.org. Let's talk about child abuse and neglect. Florida law on child abuse and neglect. Child abuse means abandonment, abuse, harm, mental injury, neglect, physical injury, or sexual abuse of a child, as those terms are defined in those statutes: 39.01, 827.04, and 984.03. Abandonment or abandon. So abandon or abandonment means a situation in which the parent or legal custodian of a child, or in the absence of a parent or legal custodian, the caregiver, while being able, makes no provision for the child's support and has failed to establish or maintain a substantial and positive relationship with the child. For purposes of this subsection, establish or maintain a substantial and positive relationship includes, but is not limited to, frequent and regular contact with the child through frequent and regular visitation, or frequent and regular communication to or with the child. and the exercise of parental rights and responsibilities. Marginal efforts and incidental or token visits or communications are not sufficient to establish or maintain a substantial and positive relationship with a child. I know this is a lot. Please stay with me. Okay, abuse, what's the definition? Means any willful act or threatened act that results in any physical, mental, or sexual injury or harm that causes or is likely to cause the child's physical, mental, or emotional health to be significantly impaired. Abuse of a child includes acts of omissions, corporal discipline of a child by a parent or legal custodian for disciplinary purposes does not in itself constitute abuse when it does not result in the harm of the child. Harm to a child's health or welfare can occur when any person, so the definition, inflicts or allows to be inflicted upon the child physical, mental, or emotional injury. So inflicts upon the child a physical, mental, or emotional injury. In determining whether harm has occurred, the following factors must be considered in evaluating any physical, mental, or emotional injury to a child: the age of the child, any prior history of injuries to the child, the location of the injury on the body of the child, the multiplicity of the injury, the type of injury inflicted. Such injury includes, but is not limited to, sprains, dislocations, or cartilage damage, bone or skull fractures, brain or spinal cord damage, intracranial hemorrhage or injury to other internal organs, asphyxiation, suffocation, or drowning, injury resulting from the use of a deadly weapon, burns or scalding, cuts, lacerations, punctures, or bites, permanent or temporary disfigurement, permanent or temporary loss or impairment of a body part or function. As used in this subparagraph, the term willful refers to the intent to perform an action, not to the intent to achieve a result or to cause an injury. Purposely giving a child poison, alcohol, drugs, or other substances that substantially affect the child's behavior, motor coordination, or judgment, or that result in sickness or internal injury. For the purposes of this subparagraph, the term drugs mean prescription drugs not prescribed for the child or not administered as prescribed, and controlled substances as outlined in Schedule 1 or 2 of Statute 893.03. Number 3, leaving a child without adult supervision or arrangement appropriate for the child's age or mental or physical condition, so that the child is unable to care for the child's own needs or another's basic needs, or is unable to exercise good judgment in responding to any kind of physical or emotional crisis. Number 4, inappropriate or excessively harsh disciplinary action that is likely to result in physical injury, mental injury as defined in this section, or emotional injury. The significance of any injury must be evaluated in light of the following factors: the age of the child, any prior history of injuries of the child, the location of the injury on the body of the child, the multiplicity of the injury, and the type of trauma inflicted. Corporal discipline may be considered excessive or abusive when it results in any of the following or other similar injuries: sprains, dislocations, or cartilage damage, bone or skull fractures, brain or spinal cord damage, intracranial hemorrhage or injury to other internal organs, asphyxiation, suffocation, or drowning, injury resulting from the use of a deadly weapon, burns or scalding, cuts, lacerations, punctures, or bites, permanent or temporary disfigurement, permanent or temporary loss, impairment of a body part or function, significant bruises or welts. All right, commits or allows to be committed. Sexual battery is defined in Chapter 794, or lewd or lascivious acts is defined in Chapter 800 against the child. So C, allows, encourages, or forces the sexual exploitation of a child, which includes allowing, encouraging, or forcing a child to 1. Solicit or engage in prostitution, and 2. Engagement in a sexual performance as defined by Chapter 827. D, exploits a child or allows a child to be exploited as provided in Statute 450.151. E, abandons the child. Within the context of the definition of harm the term abandon the child or abandonment of the child means a situation in which the parent or legal guardian of a child or, in the absence of a parent or legal guardian, the caregiver, while being able to maintain, makes no provision for the child's support and has failed to establish or maintain a substantial and positive relationship with the child. For purposes of this paragraph, establish or maintain a substantial and positive relationship includes, but is not limited to, frequent and regular contact with the child through frequent and regular visitation or frequent and regular communication to or with the child, and the exercise of parental rights and responsibilities. Marginal efforts and incidental or token visits or communications are not sufficient to establish or maintain a substantial and positive relation with a child. The term abandoned does not include a surrendered newborn infant as described in Statute 383.50. F. Neglects the child within the context of the definition of harm. The term neglects the child means that the parent or other person responsible for the child's welfare fails to supply the child with adequate food, clothing, shelter, or health care. Although financially able to do so, or although offered financial or other means to do so. However, a parent or legal guardian who, by reason of the legitimate practice of religious beliefs, does not provide specified medical treatment for a child may not be considered abusive or neglectful for the reason alone. But such an exception does not, 1. Eliminate the requirement that such a case be reported to the department, 2. Prevent the department from investigating such a case, and 3. Preclude a court from ordering, when the health of the child requires it, the provision of medical services by a physician as defined in the section, or treatment by a duly accredited practitioner who relies solely on spiritual means for healing in accordance with the tenets and practices of a well-recognized church or religious organization. G. Exposes a child to a controlled substance or alcohol. Exposure to a controlled substance or alcohol is established by, number 1, a test administered at birth, which indicates that the child's blood, urine, or meconium contained any amount of alcohol or a controlled substance or metabolites of such substances, the presence of which was not the result of medical treatment administered to the mother or the newborn infant, or evidence of extensive abusive and chronic use of a controlled substance or alcohol by a parent when the child is demonstrably adversely affected by such usage. As used in this paragraph, the term controlled substance means prescribed drugs, not prescribed for the parent or not administered as prescribed in controlled substances as outlined in Schedule 1 or 2 of Statute 893.03. H. Uses medical devices, unreasonable restraints, or extended periods of isolation to control the child. And I. Engages in violent behavior that demonstrates a wanton disregard for the presence of a child and could reasonably result in serious injury to the child. And J. Negligently fails to protect a child in his or her care from inflicted physical, mental, or sexual injury caused by the acts of another. Number 5, institutional child abuse or neglect means situations of known or suspected child abuse or neglect in which the person allegedly perpetrating the child abuse or neglect is an employee of a private school, public or private daycare center, residential home, institution, facility, or agency, or any other person as such institution responsible for the child's care. Chapter 39 of the Florida statutes mandates that any person who knows or has reasonable cause to suspect that a child is abused, neglected, or abandoned by a parent, legal custodian, caregiver, or other person responsible for the child's welfare shall immediately report such knowledge or suspicion to the Florida Abuse Hotline for the Department of Children and Families. The bill also states that the knowledge and willful failure of a person who is required to report known or suspected child abuse, abandonment, or neglect is elevated from a first-degree misdemeanor to a third-degree felony. As a result, the potential prison sentence is raised from 1 to 5 years, and the potential fine is raised from a maximum of $1,000 to a maximum of $1,000 to a maximum of $5,000. In addition, the bill creates subsections 39.205, 3, and 4. Florida statute, which provides penalties for Florida educational institutions whose personnel fail to report certain child abuse taking place in the campus of the institution or during an event or function sponsored by the institution. The bill subjects the institution to a $1 million fine for each failure to report child abuse, abandonment, or neglect. Penalties for false reporting. So certainly during custody evaluation, social investigations, if parents are fighting, there certainly can be a potential for false reporting of abuse and domestic violence for that matter. False reporting means a report of abuse or neglect made to the Central Abuse Hotline, which is made maliciously for the purpose of harassing, embarrassing, or harming another person. Financial gain for the reporting person acquiring custody of a child, or personal benefit for the reporting person in any private dispute involving the child. The term false report does not include a report made in good faith. If you make a false report of abuse in Florida, you face up to 5 years in jail and a $5,000 fine. A false report is when you knowingly make a report in the absence of suspicion. How to make a child abuse report. First, describe the situation clearly and include all the information that you have, names, dates of birth, date of birth, addresses, etc., of where it took place, where the child lives. Share any knowledge of previous incidents, including the nature and extent. Include all reactions of the child. Be sure to communicate any sense of urgency you observe. You must give your name, but it will remain confidential. But if you don't want to give your name, providing your name to the operator is proof that you made a report and followed your legal obligation. This can protect you in the future. The family is not given the name of the person reporting. This information is held confidentially. You must give your name. Okay. Now, just want to make sure everybody knows we're all basically mandatory reporters. So, healthcare providers, absolutely. But any adult that knows about abuse of a child, an elder, a disabled person, is a mandatory reporter. Okay, we have to protect the innocent. To report child abuse or neglect, I have the phone numbers listed: 1-800-96-ABUSE, fax number, okay, and a toll-free number, another toll-free number. And then the website, reportabuse.dcf.state.fl.us.